Hello friends, welcome to our channel Analytics Science Academy and welcome to our these polity classes where we have been discussing certain important issues related to Indian polity and constitution. And in same series of lectures, dear friend, today again I am here with you people to discuss one very important article of Indian constitution that has been in news recently, dear friend, that is article 143 of Indian constitution. So very recently, dear friend, President of India has invoked article 143 of Indian constitution and asked certain questions to Supreme Court of India, asking Supreme Court to express their opinion on these questions that have been raised by President of India. So what exactly is article 143 and why President of India has invoked this article 143 recently? What are those 14 questions? All these things, dear friend, in this particular session we are going to discuss. बढ़िया सेशन आपके साथ होने वाला है दोस्तों, बहुत सारी चीजें हम आपके साथ एक ही सेशन में करने की कोशिश करेंगे। बट सेशन स्टार्ट करने से पहले थोड़ी सी इंफॉर्मेशन मेरे बारे में दोस्तों। माय नेम इज पंकज शुक्ला एंड आई हैव बीन टीचिंग इंडियन पॉलिटी एंड कॉन्स्टिट्यूशन सिंस लास्ट मोर देन 1 decade. एंड इफ यू हैव एनी डाउट रिलेटेड टू पॉलिटी सेक्शन, कॉन्स्टिट्यूशन सेक्शन, गवर्नेंस और इंटरनेशनल रिलेशन, you can connect with me through these social media platform, dear friend, and whatever your doubts are there, whatever your queries are there, you can consult with me, dear friend. And now let's start with our today's topic, dear friend. Very recently, our president has used article 143 of Indian constitution and president has asked certain questions. 14 questions have been raised by President of India, asking Supreme Court of India to express their opinion on these 14 questions. So, what are these 14 questions? What are these 14 questions on which President Draupadi Murmu ji has asked something to Supreme Court of India, asking their opinion on these questions? ये सारी बातें हम आपके साथ डिस्कस करेंगे. One such question is whether some time limit can be imposed on president or governors of a state. So such kind of the questions, including other questions that have been asked by President of India. So देखिए इस पूरी कंट्रोवर्सी के सेंटर में if there is one article, that article is article 143. So what exactly is article 143? How President of India uses article 143? Why it has been used recently? What are the questions raised by President? ये सारी बातें हम आपके साथ जानने की कोशिश करेंगे और एक अच्छी से अंडरस्टैंडिंग बनाने की कोशिश करते हैं on this issue of article 143, dear friend. So देखिए article 143 refers to power of Supreme Court of power of President of India to consult highest judiciary in India, that is Supreme Court. We also call it advisory jurisdiction of Supreme Court, under which Supreme Court of India can express its opinion on certain matters that have been raised by President of India. But from precedent parts, it is power of President to consult Supreme Court of India on certain matters. And this power of President that is available to Indian President, this power is so unique, dear friend, that it is not available to even President of US. So ये जो power है Indian President की, using article 143, that they can consult Supreme Court of India, such power is not available to even US President of US President. That is available to Indian President. But ये power है क्या दोस्तों? Under article 143, President of India can consult Supreme Court of India, that is highest judiciary in India. What exactly is that power, dear friend? Using this power, dear friend, under article 143, President may seek opinion of Supreme Court. President may consult Supreme Court of India on any matter, whether these matters are pre-constitutional matter or these matters are post-constitutional matters. Pre-constitutional matter means a matter that may have happened before commencement of Indian Constitution. Post-constitutional means the matter has occurred after commencement of Indian Constitution. So दोनों तरह के matter President of India they can raise before Supreme Court of India, asking their opinion, asking their consultation on such kind of matter. In case of pre-constitutional matter, if matter is being referred to Supreme Court of India, it is binding on the part of Supreme Court to express their opinion. But in post-constitutional matter, Supreme Court, they may or may not give their advice. But in any case, whatever opinion is expressed by Supreme Court, It is advisory in nature. President may or may not accept such advices of Supreme Court of India. But one thing is very clear, that whenever any matter is referred to Supreme Court of India under Article 143, जब भी किसी मैटर को सुप्रीम कोर्ट ऑफ इंडिया को रिफर किया जाएगा अंडर आर्टिकल 143, in order to consult, सुप्रीम कोर्ट ऑफ इंडिया विल फॉर्म ए 5 जजेस कॉन्स्टिट्यूशनल बेंच. जब भी कोई मैटर प्रेसिडेंट ऑफ इंडिया रिफर करेंगे किसे, सुप्रीम कोर्ट ऑफ इंडिया को, सुप्रीम कोर्ट ऑफ इंडिया विल फॉर्म ए 5 जजेस बेंच, what we call as constitutional bench, to consult, to deliberate and to discuss on such matter. Later on they may extend their opinion to President of India. But very recently, dear friend, this article came under news, dear friend. Why? Because something has happened in context of Tamil Nadu government, dear friend. Tamil Nadu government के context में कुछ तो भी हुआ है, that will have far-reaching effect. That will have far-reaching effect on certain articles under Indian Constitution, especially Article 200 and Article 201. So again, till now we were talking only about Article 143. Article 143 has been in news. Why it has been in news? Because something has happened related to two important articles of Indian Constitution, Article 200 and 201. So Article 200 of Indian Constitution और आर्टिकल 201 ऑफ इंडियन कॉन्स्टिट्यूशन, इन्हें लेकर रिसेंटली कुछ हुआ तमिलनाडु गवर्नमेंट के कॉन्टेक्स्ट में, जिस वजह से आर्टिकल 143 न्यूज में आया, जिस वजह से प्रेसिडेंट ने 14 क्वेश्चंस पूछे हैं किससे, सुप्रीम कोर्ट ऑफ इंडिया से. तो हुआ क्या है दोस्तों, लेट्स ट्राई टू अंडरस्टैंड दिस. देखिए, अंडर आर्टिकल 200 ऑफ इंडियन कॉन्स्टिट्यूशन, व्हेन एनी लेजिस्लेटिव प्रपोजल, पॉपुलरली कॉल्ड एज बिल, व्हेन एनी लेजिस्लेटिव प्रपोजल और बिल पास बाई स्टेट लेजिस्लेचर, स्टेट की जो लेजिस्लेचर या लेजिस्लेटिव असेंबली है उससे पास होकर जब कोई बिल गवर्नर के पास जाता है, गवर्नर हु इज द कॉन्स्टिट्यूशनल हेड एट द स्टेट लेवल, व्हेन एनी बिल पास बाई स्टेट लेजिस्लेचर, डियर फ्रेंड, इट गोज टू गवर्नर ऑफ द स्टेट फॉर हिज अप्रूवल एज पर इंडियन कॉन्स्टिट्यूशन अंडर आर्टिकल 200. एज पर इंडियन कॉन्स्टिट्यूशन अंडर आर्टिकल 200, गवर्नर हैज सर्टेन चॉइसेस. गवर्नर के पास कुछ चॉइसेस हैं. व्हाट आर दोस चॉइसेस? गवर्नर मे गिव हिज असेंट, गवर्नर मे गिव हिज अप्रूवल टू द बिल, बिल बिकम्स एन एक्ट, गवर्नर मे विदहोल्ड हिज असेंट टू द बिल, गवर्नर मे से नो, और गवर्नर मे सेंड दिस बिल फॉर reconsideration of Council of Ministers. So governor may send it for reconsideration. So these are the three constitutional choices available before governor of any state whenever any bill passed by state legislative assembly is forwarded to governor for his approval. That is there under Article 200 कि गवर्नर अपना अप्रूवल दे सकते हैं, गवर्नर अपना अप्रूवल देने से मना कर सकते हैं, और गवर्नर में सेंड दैट बिल फॉर again reconsideration, dear friend. So these are the choices, dear friend. Another choice before governor is under Article 201. Under Article 201, dear friend, governor of any state, he may reserve that bill for reconsideration of President of India. ये fourth choice है. That is the fourth choice before governor, but that is mentioned under Article 201. But very recently, in a case related to Punjab government and governor of Punjab, Supreme Court of India held, popularly known as Punjab case. Punjab case में Supreme Court of India ने बोला कि whenever governor is withholding his assent on a bill, bill will not die. It will not amount to death of the bill. Whenever governor declares that he is withholding his assent to the bill, he send back that bill to the concerned state legislature. जो state legislature है उसके पास आपको भेजना पड़ेगा इस बिल को अगर आप विदहोल्ड कर रहे हैं. एंड अगेन इफ दे आर सेंडिंग इट बैक, अगेन इफ दे आर सेंडिंग इट बैक टू द गवर्नर, देन गवर्नर हैज टू गिव हिज अप्रूवल विद इन 1 month. सो विद इन 1 month गवर्नर हैज टू गिव हिज अप्रूवल. सो दैट इज द आइडिया, डियर फ्रेंड, दैट बिल विल नॉट डाई if after reconsideration state legislature is again sending it back, so governor will have to give his approval. But in all these cases, governor is giving his approval, governor is withholding his approval, governor is sending for reconsideration, or governor is reserving for the reconsideration of president, no time limit is mentioned. Whenever governor of any state, he exercises any such option, dear friend, any such option under Article 200, no time limit was mentioned under Indian Constitution. Neither under Article 201. When governor is reserving that bill for reconsideration of president, in what time frame president will give his assent or president will not give his assent, no time limit was mentioned under Indian Constitution. कोई time limit mention नहीं था under Article 200 or under Article 201. So कोई time limit was not mentioned. Very recently what happened, dear friend, Tamil Nadu government or Tamil Nadu Legislative Assembly, they passed 10 bill, dear friend, and these 10 bill, they were forwarded to governor. Governor declared that he is withholding assent on certain bill. Governor reserved certain bill for the reconsideration of president, but nothing was happening, dear friend. Nothing was happening on those bills. So bills that went to the governor, certain bill governor, he sent to the president, but nothing was happening on those bills. And certain bills were there with the governor, nothing was happening on that bill, dear friend. So, as such, governor or president, they were exercising pocket veto on these bills, dear friend. They were exercising pocket veto on these bills. Then what happened? Tamil Nadu government, they approached Supreme Court. Tamil Nadu government, dear friend, they approached Supreme Court. And Supreme Court of India, in that case, dear friend, they gave a landmark judgment. They gave a landmark judgment. Supreme Court of India का कहना है कि when bill has been passed by state legislature and it is pending before governor for his approval, or for that matter presidential approval, governor has sent that bill for reconsideration of president, and if no action is taking place, on such bills that have been passed by concerned state legislative assembly, it amounts to ignoring the wish of people. इसका मतलब ये है कि आप लोगों की विश को क्या कर रहे हैं, इग्नोर कर रहे हैं, ऐसा कहना है सुप्रीम कोर्ट ऑफ इंडिया का. सुप्रीम कोर्ट ऑफ इंडिया हेड that it is not like that, there is no time limit, dear friend. There is time limit, and that time limit is 3 months. Within 3 months, governor should declare that he is withholding his assent to that bill, and he should send that bill to the concerned state legislature. And after reconsideration, if concerned state legislative assembly, they are again sending back that bill, then within 1 month, governor has to give his approval. Within 1 month, governor has to give his approval. So Supreme Court, they are saying that there is a time limit, and within that time limit, you have to take your decision. If governor is withholding his assent on that bill, he has to declare that thing within 3 months, and he should send it back to the concerned state legislature. But if concerned state legislature, if they are again sending back that bill in same form or modified form, then within 1 month, governor has to give his approval. So now there is a time limit on power of governor under Article 200, dear friend. Under Article 200, now there is a time limit on the power of governor. Within that time limit, you have to take your decision. So some critics, they are saying it is a kind of disturbing the balance among 3 organs of government. जो हमारे 3 organs of government हैं, legislature, executive and judiciary, ये इनके बैलेंस को क्या कर रहा है, डिस्टर्ब कर रहा है. Judiciary, in the name of judicial activism, they are actually indulging into judicial overreach. Our vice president, he also went on to criticize. इन्होंने भी क्रिटिसाइज किया. इन्होंने बोला कि सुप्रीम कोर्ट, दे आर यूजिंग आर्टिकल 142 एज ए न्यूक्लियर मिसाइल, डियर फ्रेंड. अंडर आर्टिकल 142, सुप्रीम कोर्ट ऑफ इंडिया, they can give any order, in order to ensure complete justice, and in this case, 10 bills that have been passed by Tamil Nadu state legislature, they were deemed as they have been approved by president or governor of the state, and for the first time, dear friend, these bills became an act without presidential approval or governor's approval. Unprecedented, dear friend. Unprecedented. So, under Article 142, Supreme Court of India can give any order in order to ensure complete justice, dear friend. And accordingly, these bills, they have become an act. Further, Supreme Court held that whenever any bill governor is sending for the reconsideration of President of India must consult Supreme Court of India related to such bill, whether he should give his opinion or he should not give his opinion. That is also something unprecedented, that whenever any bill is reserved for presidential reconsideration passed by state legislative assembly, then President has to consult Supreme Court of India to give his approval or not to give approval. And if either President or Governor of a state, they are not abiding by these judgment of the Supreme Court or the time limit that has been fixed by Supreme Court, then Supreme Court may issue writ of mandamus. Writ of mandamus, हमने आपके साथ already discuss किया था कि writ of mandamus cannot be used against President and Governor of a state because they are not answerable to any court of law working under Indian Constitution for their official duty. But here Supreme Court of India has said that they can issue this writ of mandamus against Governor or President of India. ये बात समझ पा रहे हैं? So देखिए, when such kind of a judgment came from Supreme Court, number of constitutional experts, they have argued that it is misuse of the authority of the Supreme Court. It is a misuse of the authority of Supreme Court. Then on the advice of Government of India, on the advice of central government, President of India invoked Article 143 and raised 14 such pointed questions for Supreme Court, asking their opinion on these questions. These questions are like, what are the constitutional options available to governor when presented with a bill under Article 200? Options we have already discussed, but President is asking, give me clarity on these options because you are imposing time limit. You are saying you will issue mandamus. So you are rewriting the Constitution. Supreme Court should act as an interpreter of Constitution. But again, President is saying that the kind of the judgment you have given in context of Article 200 and Article 201, it appears, it seems that you are rewriting the Constitution. So such kind of the 14 questions, these questions you may see on your screen. Is the governor bound by the advice of the Council of Ministers in exercising his option available within him when a bill is presented before him under Article 200 of the Constitution? Is the exercise of the constitutional discretion by the governor under Article 200 of the Constitution is justiciable? क्या judiciary in matters में interfere कर सकती है? तो such 14 questions that have been raised by President of India for Supreme Court's reference. So that's why, dear friend, Article 143 has been in news. I hope Article 143, Article 200, Article 201 and Article 142, you might be able to understand, dear friends. So if you have any doubts, so please send your doubt on the links that I have shared with you. So if you are preparing for 2026 examination, dear friend, and if you want to prepare for Civil Service Examination 2026 in a very channelized manner, in a structured manner, so we at Analytics IAS Academy are going to launch our new foundation batch. The date for the new foundation batch is, dear friend, 5th May, dear friend. 5th May, we have already started, dear friend. Next batch that we are going to start, that is from 5th June. So if you are interested, you can call on the given number and you can resolve all your queries related to that course. Thank you to all for joining me and for staying with me, dear friends. Thank you.